Judgment in the appeal in the matter of an application by JR17.
This is an appeal from the Court of Appeal of Northern Ireland. The issue is whether a pupil was unlawfully suspended from his school in County Antrim. His school fell within the area of the North Eastern Education and Library Board. The board had prepared a scheme governing the suspension and expulsion of pupils. It had done so pursuant to the requirement of the Education and Libraries Northern Ireland Order 1986. The appellant was suspended following a complaint by a girl pupil at the school of misconduct in relation to her, which she insisted that the principal of the school should keep confidential. The principal suspended the appellant to protect this pupil pending a risk assessment, stating that he did so as a precautionary measure. Although he purported to suspend the pupil pursuant to the scheme, he failed to comply with its requirements. The appellant brought proceedings for judicial review, contending that his suspension was unlawful and denied him the right to education guaranteed by the European Convention on Human Rights, contrary to the Human Rights Act 1998. The Court of Appeal held that the principal had lawfully exercised a common law power to suspend the appellant that existed as part of his managerial powers in parallel with the power conferred under the scheme. The Supreme Court has reversed this finding to the extent of holding that the principal had had no such power. Sir John Dyson, Lord Phillips and Lady Hale have held that the suspension was disciplinary, or at least had been imposed in a disciplinary context, and that no common law power to suspend subsisted in these circumstances. Lord Roger and Lord Brown have held that the suspension was a precautionary measure rather than a disciplinary sanction, but that there was no common law power to suspend outside the scheme. It follows that the suspension was unlawful. The court held that the suspension did not amount to a denial of the right to education guaranteed by the Convention. Accordingly, the court orders that the appeal be allowed, a declaration be made that the appellant was unlawfully suspended from school from the 7th of February 2007 until the 20th of April 2007, that there was no breach of Article 2 of the First Protocol of the European Convention on Human Rights. The court invites submissions in relation to the respondent's liability to pay costs, but this is all right. The appellant's costs should be taxed in accordance with Schedule 2 of the Legal Aid, Advice and Assistance Northern Ireland Order 1981.
Judgment in the appeal, Austin and the Mayor and Burgesses of the London Borough of Southwark.
Lord Hope will deliver this judgment.
More than 18 years ago, the appellant's brother fell into rent arrears in respect of a dwelling house which he rented from the London Borough of Southwark on a secure tenancy. Southwark obtained a conditional possession order from the court that entitled it to evict him if he failed to pay the arrears by a specified date. He failed to do this, but rather than evict him, Southwark opted to allow him to remain in the property. He stayed there until his death 18 years later, paying the rent as it became due and making some contribution towards the outstanding arrears. The appellant says that he moved in to live with his brother and that for the 12 months prior to his death, he nursed him there through his terminal illness. The issues which this court must consider will determine whether Southwark are now entitled to evict the appellant or whether he might be able to remain in his brother's house as a secure tenant of the property. Long-standing authority holds that his brother's secure tenancy was effectively terminated by the brother's failure 18 years ago to pay the arrears of rent by the date specified in the conditional possession order, notwithstanding that Southwark allowed him to remain in the property and collected his rent for almost 2 decades thereafter. He became what has become to be known as a tolerated trespasser. This jurisprudence was challenged in this appeal. It is confusing and unsatisfactory, but the court has decided, not without regret, that it is now too embedded in our statutory and common law to be overturned by the courts. But for the situation exemplified by this case, however, the problem has been solved by Parliament. The Housing Act 1985 confers a right on a secure tenant to petition the court for an order suspending enforcement of a possession order after it has become enforceable. the court has concluded that the brother's secure tenancy was terminated when he failed to pay the rent arrears by the specified date. So the question is whether the right to petition the court to postpone enforcement of the possession order survives death and passes to the estate of the deceased's former tenant. Until now, decisions of the lower courts have indicated that the right could not survive death as it was not an interest in land that was capable of being inherited. If this is right, it would mean that the right to apply for postponement of the possession order would not transmit to the appellant. Southwark could now be entitled to obtain possession of the property, and the appellant would inevitably be removed from it. The Supreme Court unanimously holds that Section 85(2) of the Housing Act 1985 does not compel this conclusion. The question whether the right to apply can survive the tenant's death depends on the terms of the statute. It provides that the right can be exercised at any time before the order for possession is executed. That being so, there is no reason why it should not be exercised by the appellant as the deceased's personal representative. The case is accordingly remitted to the county court to determine the appellant's application for a postponement of the possession order. This decision closes the gap left by Parliament. So, not before time, we can at last say goodbye to the tolerated trespasser.